broadly speaking, revolves around platform accountability, social media, and freedom of expression. So I'll kind of touch on the question of platform accountability and what the current legal framework provides. So if you look at the Cyber Protection Act that was legislated this year, which has been sort of taken from the ordinance during the interim government, and of course somewhat a legacy of its predecessors from 2018, 2023, we see there is nothing in the law that actually holds the platforms accountable. There are no positive obligation on social media companies and other intermediaries to proactively address online abuses, harmful content, illegal content. From a more practical perspective, what we have seen, and we've seen a lot of our colleagues handle, like Blasters in the room here today, they've also handled a lot of complaints, but the complaints are made by victims themselves against other individuals, but nothing in the law can directly hold the platforms liable unless you're relying on vague provisions around aiding and abetting of offenses, which again is a very difficult case to prove in a court of law. And then you sort of move downward and you see there are something that resembles a notice and take down mechanism. Notice and take down mechanism, again, is very poorly drafted. There are established models that we could have taken inspiration from, but right now, the model that exists in the law, I think it's in Section 8, unfortunately, barely addresses the ways in which it should be done, relevant procedural guardrails. In reality, what it seems to do is to empower certain regulators, specifically BDRC, to send requests, which again are not binding orders, with no real obligation on platforms to really take them down or action those content. And as a result, we've seen that there have been incidents of online conversation escalating into offline harms. The other point I would like to make very briefly, before I pass on the conversation to someone else, is that the recent amendment to the Telecom Act is quite startling. There is a conflation between telecom services and online service provisioning of online services. This conflation of telecom service providers with online intermediaries, which begs the question, are platforms now required to be registered under Bangladeshi law? Are they subject to the same penalty regime as legacy telecom service providers? And if so, what does that mean in terms of freedom of expression, and privacy, especially since we now have more comprehensive provisions around interceptions and surveillance? So these are some open questions I hope members present here today could potentially address. If not, these are serious questions to be considered moving forward. Thank you very much. I really appreciate the candid conversation we've been having, and more than anything, I feel that there are more opportunities for us to collaborate, civil society, government, and other actors in the room. I'll try to keep it as specific and as concise as I can, and elaborate on some of the observations that have been made in the last hour or so. So I'd like to start with something that Dr. Joanne Barata mentioned about platform liability, that assignment of responsibilities to platform is, it could be seen as privatization of regulatory responsibilities of authority, which is bad for freedom of expression. To some extent, I do agree with that stance, but at the same time, what the Cyber Protection Act is currently lacking, and something that desperately requires, and which is something already there in comparable legislations in the EU, in Australia, in the UK, is platform accountability more from the perspective of platform design, platform processes, and platform systems, which is not there. So at the end of the day, Major General Bari has mentioned that certain things needs to be done, but how do we how do we compel the platforms to do them? Because there are no legal basis to start with. So we need the legal basis. We need a major overhaul of the current legal instruments, as Major General Bari mentioned, that we should start with the legal instrument, but it needs to be structured correctly. Right now, in its current form, it's not. There are too many ambiguities and there are too many gaps in the legislation. The second point, with reference to what Mr. Rehan Asif Asad mentioned, focusing on the term cybersecurity, I think it's an interesting it would be an interesting intellectual exercise for us to sort of separate, or at least consider separating cybersecurity from content governance, because these are two fundamentally separate issues. And the moment we start conflating one with the other is the moment we start facing not only interpretation challenge but also enforcement challenges. The third point, and the penultimate point, is with respect to the Data Protection Act. Sure, it's a better version of the draft than what we've seen 4 or 5 years ago, without data localization provisions, without the penalty regime, punitive penalty regime. But what's really slightly concerning from my vantage point is the fact that there's an 18-month grace period given for which broadly aligns with the GDPR model. But the challenge I have with this 18-month grace period is EU's had decades of experience, sort of evolving its institutional, its legal, its jurisprudential sort of foundation to get to a stage where 2-year grace period made sense. Bangladesh does not have those foundation to begin with. So, and nothing has been done, because this act has retrospective effect from 5th of November, if I'm not mistaken, of last year, which means we've already lost 5-6 months, and nothing has been done to actually raise awareness and to ensure that companies going forward are being compliant. So I would like to see more activities on that front. And the last one, the last point I would like to make is, again, going back to BTRC and Major General Bari, is that thank you very much for sharing some of the statistics. These are not publicly available. We would appreciate if we could get similar statistic going forward on the number of takedown requests sent, action category-wise, without having to necessarily go through the RTI route, which has its own share of challenges. But it's something, these sort of information for researchers like us are very helpful when we're having conversations about platform accountability, why they're actioning certain content, why are they not? Is it necessarily because of the legal system, our legal system, or gaps in our legal system, or something more to do with their community standards, so on and so forth. So I think from a research perspective, I think it's very important that we have these information. Thank you very much.